Okay, welcome to a session on small and large building works contracts. So basically what we're going to be covering in this particular session is talk about the purpose of contracts. So why do we need to enter into small or large building works contracts? We'll talk about the rules in relation to small and large contracts. So at law, what do we need to do for each of these particular types of contracts? Number three, we'll talk about the types of contracts, and there's a few industry contracts out there that our strata managers may be using. We'll also move on to the how. Discuss really briefly BMC, so Building Management Committee. So what's different in relation to them with regard to the entering into of contracts and works generally. And everyone's favorite point, charging add-ons. So we'll finish off with that. So let me start off with the purpose. So first and foremost, covering the owner's corporation and the builder, and obviously protecting them, both parties with a contract is super duper important. So the purpose, number one, is protection. So protect the owner's corporation's position, warranties, etc., and also protect the obviously the builder, whoever it is that are doing the works, the contractor. Establish payment terms, so super important. Confirming the scope of works. Requirement at law with regard to the Home Building Act 1989 or HBA. So you do actually have to enter into formal contracts between $5,000 and $20,000 worth of work. It is considered to be a small jobs contract, and anything above $20,000, slightly different. It is a large or a large works contract, so above $20,000. So residential building work worth more than $20,000 requires an extensive home building contract. So we'll talk about that. All right, small versus large. So again, 5 to 20 is the small works contract, and the large works contract or extensive home building contract, as it's referred to, is those works above 20,000. And there's some subtle differences between the two. So for small jobs, 5,000 to 20,000, the parties' names obviously have to be listed correctly. And obviously, what I'm talking about there is not a party yeehaw, party animal out at the pub. I'm talking about the party as in the owner's corporation strata plan, blah, blah, blah. And, Joe Bloggs Waterproofing Proprietary Limited. So names listed correctly. The name of the holder of the contractor license, obviously the contract license number, description of the work. So obviously, what are they doing? That is normally accompanied with obviously any sort of scope of works or plans, which obviously, for the large building works contracts, that's probably more of an issue. If you've got a $5,000-$6,000 job, maybe there's a brief description of the work that you would include in that small works contract. Obviously, any plans or specifications for the work, the contract price is important. So how much money do the works cost? Quality construction clause and contractor's liability clause, which, you will find that detail in the standard form contracts anyway, and information sheet about registered certifiers where certification is required, and provision indicating the client's freedom to choose their own certifier. Now, on top of the requirements for a small job, the large jobs or the large works contracts need all of those things plus the items that are on the right-hand side of the page there. So large jobs, 20K plus, all requirements as noted for small jobs, as I've just mentioned. Relevant warranties required by the HBA, Home Building Act. Also, there needs to be the addition of a cooling off period, so of 5 clear days. Contract checklist. So there's a checklist in the standard form contracts that needs to be filled out, and it is included as part of the works contract, and a caution statement, as well as consumer building guides. Obviously, the consumers need to be well aware of their rights entering into the contract. Progress payment statement. So basically how that works in essence is, is it a certain percentage of the work? So if it's a $100,000 contract and it's broken up by payment terms of, $20,000 or particular works, and obviously states the value of those particular works, super important to, know about that up front. What I will say with the payment statement point there is if you are doing a large, building work project, also be mindful that if money is tied up in a Macquarie Bank or any other sort of term deposit, you do need to give the bank 30 days notice to retrieve the money back into the general day-to-day trust account. So if you, for example, doing a $100,000 job, you've got, the money tied up in a term deposit, only 10 grand in the general trust account. If you receive the contractor's bill, but you've forgotten to retrieve the money back from the bank, giving them 30 days notice, then you'll be left looking a bit silly. And if there are certain payment terms of 7 or 14 days, then those payment terms may not be able to be met, because obviously the money could still be locked away in a term deposit for 6 months or 12 months or so forth. So look out for that one. Termination clause. So if all things go belly up, how do you get out of the contract? And that would apply both ends. So the contractor versus the owner's corp. Home building compensation insurance. So that's the new or newer term for home warranty insurance. So obviously that's applying to large jobs, so look out for that. Statement about compliance with the Home Building Act, so development consent, that's got to be in the contract. And again, the information sheet about registered certifiers makes an appearance as well. Moving on, other contract considerations. Think about liquidated damages. So for non-compliance to the contract. So what is all that about? Is basically, let's say you've got a project, $500,000 worth of painting. The contractor has said it will take 6 months. You've got, all the owners' corporations' balconies cordoned off. They can't use them. The work rolls out to 12 months. There is usually some sort of clause or liquidated damage that the contractor or builder would then reimburse, or would be taken off their invoices, to basically reimburse the owner's corporation, I guess, for the inconvenience or the non-compliance to the actual contract terms. Also, response time. So when and this dovetails into the next point about variation arrangements. So response times, I guess, if a builder has scaffolding up and they say, dear owners corporation, we've got a variation, we've got render works that we've noticed, we estimate it to be $15,000, et cetera, there might be a certain time frame that you have to respond. Otherwise, potentially the price could go up because the scaffolding is going to be removed. So each party would have to have certain response times, adhered to, especially for the larger projects. Variation arrangements. So you'd really want to be talking about this up front with the contractors. So in terms of, what types of things, could be considered as a variation, what is included in the standard, contract, and then obviously moving forward from there, how variations are submitted. So generally speaking, the larger the job, you might have a superintendent or a consultant overseeing the job. Ordinarily, any variation request would go to them. That would then be forwarded to the owner's corporation via the strata manager for their consideration and approval. Final certificate arrangements. So when you get to the end of the job, who is signing off on the works? So I would always advise, in any large work, it really is, worthwhile having a superintendent or a consultant oversee the work to say, yes, it's been done in accordance with, Home Building Act, Australian standards, whatever it is that they certify it to these days, and then obviously issue that final certificate to the owner's corporation, again, via the strata manager, to make the final payments, etc. So generally, a certificate is received before you would make a progress payment. So that's basically how it works. Powers to suspend or terminate. So that would have to be considered in the contract. Any supplementary terms or documents. So there might be certain additional conditions that the owner's corporation might want to put into the contract, or potentially the builder might want to put into the contract. For example, that they be given, 3 visitor car parking spaces for 6 months while they're painting the building, or something to that effect. And obviously including any drawings, plans, or specifications in relation to the job. All right, so home building compensation fund insurance. So previously homeowners warranty insurance. A couple of key points there on the screen. So it's done by iCare, HBCF, you can see on the right there. So compulsory for residential building work over 20,000. And building work means, by definition, construction, alteration, repair, or decoration of a dwelling, but various work. So some inclusions and exclusions apply. So multi-story buildings may be excluded. So pursuant to Reg 57 of the Home Building Regulation 14. So multi-story means basically that has a rise in story more than 3. So home building compensation fund would really be for that 3 stories or less scenario. So anything greater than that, there are those exclusions there under Reg 56. Cover is limited to $340,000 per dwelling with an excess of $250. Cheap excess, nice. 6-year major defect warranty, 2-year non-major defect warranty. So the standard Home Building Act warranties would apply. And the cover is limited to circumstances where the builder or developer has been shot in the head. No, it doesn't have to be shot in the head, but they've died, become insolvent, disappeared, or in some circumstances been subject to license suspension. So look out for that one. All right, some types of contracts. So standard form contracts. Any sort of standard contract, you have to consider who it was drafted by, right? So HIA, for example, are an industry association who basically act and represent builders. So their owner suitability, I've got a little rating here on the screen, might be sitting at, say, 40%. So they're not as consumer friendly. They're more backing the position of the builder or the contractor. Whereas New South Wales Office of Fair Trading, complete polar opposite. So they are going to be, more, consumer friendly. So their clauses are going to be drafted in a way that benefit the lot owner or the owners corporation more than they would the builder or developer. We've also got the SCA contract, so standard works agreement. So a little sort of image there on the screen. Again, not too far off the New South Wales Office of Fair Trading sort of owner suitability ratio there. So I've had a look at these, and also a bit of credit to Bannerman's lawyers. They did a comparison that I used when or read through when I drafted this particular training session. And basically, pulled some data off that to be able to show you here. So the standard form contracts tend to sway in a particular way, as I said. So be careful whose contract you're using, and obviously, with larger building works, quite often you may get a solicitor or a lawyer involved to draft a specific works contract that might suit the situation a bit better than these standard form contracts. Obviously, owners corporations may go down that road, but obviously that's more expensive than just grabbing a standard template and running with it. So types of contracts, whole bunch of different industry associations that run them, right? So New South Wales Fair Trading have a standard form agreement. Strata Community Association, as I said, have a thing called the Strata Works Agreement. We've got the Australian Standard agreements there, which you actually have to purchase, I believe. Australian Institute of Architects have an agreement that I've seen floating around. MBA or Master Builders Association, again, same as that HIA or Housing Industry Association, obviously geared more towards the contractor. All right, so again, a little bit of credit to Bannerman's. So in Strata Resources, we have a whole pile of these standard form contracts. On the right-hand side is a nice little comparison. So it sort of rates the owner friendliness versus, strata scheme suitability there. And you can sort of see the ratios there. So I guess for the consumer, the New South Wales Fair Trading, small and large works contracts are probably the go. Second, thereafter would probably be the SCA agreement. So, feel free to jump in there and have a look at those. All right, the how. So basically, how are contracts entered into? So let's first start with, let's think about the whole process. So ordinarily, what happens with works, right? So you need to get a tender. So obtaining tenders or quotes for a job is obviously a logical place to start in order to understand what approval and contract is required. So if you don't know how, what the value of the works are, then obviously a little bit hard to, stick it in the small contract or large contract. So approval for the works, so generally speaking, small jobs can be approved using delegation or strata committee approval. Large jobs should be approved at a general meeting. So larger sort of works contracts, obviously due to the monetary amount. Obviously, remember that there are clauses in the legislation, works for large schemes over $30,000, generally require 2 quotes. So consider that. Executing the contract is the next point. So review and complete the contract. For large and or complicated work, consider legal advice. So if you've got, $500, $200, $300,000 worth of remedial works or even more, I'm hearing, 12 lotters getting $1 million worth of works done and that sort of thing. Obviously, a bit of legal advice to make sure the contract, acts in the best interest of the owners corporation is super important. Also consider the payment terms. So ensure funds are in the bank. And as I said before, notice period needs to be given to banks whereby the money is locked up in a term deposit. So what do? We obviously get tenders for the work. We communicate that with the owners corporation. We look for what levels of approval we need for particular types of work. Obviously, once the approval is given, we execute the contract, and then obviously we, adhere to the payment terms. Now, outside of that, the larger the job, obviously you may consider a consultant or what we call a superintendent to oversee the work, etc. So using delegated authority, knowing where the line is. So agents with delegated authority, obviously need to have the trust there with the owners and the strata committee. So no point just signing $15,000 works contract if you know that the owners corporation would generally want to see the works contract and obviously the tenders and that sort of thing. So communicating effectively with the committee is important, and obviously knowing the limit of what you can approve and what needs to be put to the committee or the owners. So generally speaking, as I said before, 5 to 20 grand, you would consider that could be approved using delegation, or if you do need to run off to the committee, do so. Large jobs, I'm advising, really should go to general meetings. BMC, so a few points to consider here. They're not a legal entity, so then what can't they do? Well, they can't engage contractors, and obviously they can't obtain insurance in the name of the BMC because they're not an entity. So, and they can't enter into works contracts and cannot be a party to legal proceedings. So with that in mind, what's the remedy? Well, BMCs enter into agreements by having each of their members execute the contract. So for example, let's say Stratum Lot 1 is Owners Corporation 99554, Stratum Lot 2, Owners Corporation 99556, Stratum Lot 3 is a supermarket lot. So what would generally happen, let's say you're entering into a building contract of, $50,000 or whatnot, and it's a shared facility. You would be listing each of the stratum lots or entities that are a party to the building management committee. And then ordinarily you would have the common seal applied and the representative sign on behalf of that scheme or subsidiary. So a little bit more of the process. So let's say the BMC's facade was a shared facility. Another example here, and let's say $500,000 to repaint the external render. Think about this. So each subsidiary strata scheme generally would pass a motion instructing their representative on how to vote prior to a motion being approved at the BMC level. And obviously with works of that sum or value, I know this is a larger example, you would, 9 times out of 10 need to raise additional money anyway, or obviously it's a considerable contribution from each subsidiary scheme to obviously transfer to the BMC. So we need to be making sure we're doing this properly. So contracts would be reviewed and each entity would have their representative execute the contract and apply their common seal once a BMC meeting has occurred and the members confirm their instruction. Next, each entity, strata or non-strata, would normally need to execute the contract. So check the management statement. So who needs to execute the contract and how? Always check the statement. It may have specific requirements in terms of entering into works contracts. So an example of executing a BMC contract. So here you can see on the right, so this is one of our management agency agreements with 6 subsidiary strata schemes there. And you can see that, so Christine's signed this one. You can basically see that we've got 6, representatives signing the agreement. And obviously our strata manager has. So this is an example of, say, a strata management contract, but you're entering into the contract the same way you would, a works contract. Each entity is a party to the contract. It's not the BMC itself. Again, the BMC is not a legal entity. It relies upon the stratum lots to obviously execute the contract. All right, so add-ons. So what should we be charging for in relation to contracts? So you almost certainly should be setting up a task and obviously reviewing and completing the contract and time recording, arranging for any legal review. Obviously, you could charge for that, affixing the common seal. So again, most agency agreements allow for that. Coordinating the signatories. So obviously, for BMCs, etc., where you've got to coordinate multiple people to execute a contract, you would obviously have time associated with that. Arranging payments as per the terms of the contract. So again, for large works, you generally are waiting for payment certificates to be received. and then obviously, sending the invoice through to the invoice department and moving forward from there. Arranging, actions arising out of the contract. So if you've got to suspend contractors or terminate them, etc., then potentially there's time allocated there and potentially another charge. Arranging certifiers where required, reviewing and seeking consent for variations to the contract, attending the site to review work. So we should be time recording all of those events. Nice, nice, neat and tidy, recorded against the task in SMP. So use the task in the system to record the actions and the time that you're spending on the contract. Communicate, obviously, regularly with the owners. Budget for your time is super important. So if you're doing a $500,000 job and you anticipate that it's going to be a 6 or 12-month job, you might be out at site half a dozen times during that process. Budget for your time, budget for your administrative time as well, and be very clear at the outset of any project that it's an additional service that we're providing by administering or inspecting works. And okay, we're not the engineer out there signing off on things, but obviously we're the conduit between all parties, and we really should be charging for our time and valuing our time. All right, and that is it. So any questions that you have, please direct them to me. More than happy to help. I know there's quite a bit to sort of digest there, but yeah, as I say, feel free to reach out. Thanks for listening.